West Virginia is an interesting case when it comes to habitability law because for a long time, the state had very limited statutory protections for tenants. But that doesn't mean landlords can ignore their obligations. Let me explain how it works. West Virginia doesn't have a comprehensive residential landlord-tenant act like many other states. Instead, habitability requirements come from a combination of common law, the implied warranty of habitability recognized by West Virginia courts, and local building and housing codes. The landmark case that established the implied warranty of habitability in West Virginia is Teller v. McCoy, decided by the West Virginia Supreme Court. This case confirmed that every residential lease in the state carries an implied promise that the property will be fit for human habitation, regardless of what the written lease says. Under this standard, landlords in West Virginia must maintain the structural integrity of the property: roof, walls, floors, and foundation. You must provide functioning plumbing and sewage systems, ensure the electrical system is safe, provide adequate heating, keep the property free from serious health hazards, and comply with any applicable local building or housing codes. Now here's where West Virginia differs from more heavily regulated states. Because the obligations are largely rooted in common law rather than a detailed statute, the enforcement mechanisms are less defined. There's no specific statutory repair and deduct remedy on the books. Instead, tenants typically need to pursue remedies through the courts, filing claims for breach of the implied warranty, seeking rent abatement, or arguing constructive eviction if conditions are severe enough that the property is essentially unlivable. Some municipalities in West Virginia do have their own housing codes with inspection and enforcement mechanisms, so local rules matter here. Landlords should check with their city or county building department to understand what additional standards may apply. The practical takeaway: even without a detailed state statute, West Virginia landlords are still legally required to provide habitable housing. Courts will enforce that obligation, and the less proactive you are about maintenance, the more legal exposure you carry. For a complete guide to West Virginia habitability requirements, visit tenantscreeningbackgroundcheck.com and subscribe to our channel for the rest of our state-by-state series.